The reason why custodial interference is not enforced in the state of Florida, 787.03, is because there are problems with how the law is written, right? And we have, I think, 4 case law examples that I can potentially put in the notes here that show that the courts have determined that the law is written sloppily. And on its face, it appears to be constitutional. So it's not a matter of how it appears on its face, but it has the effect of being unconstitutional. And I'm going to try to address that really simply. If everybody will look up Florida Statute 787.03, you will see that in subsection 2, it says any parent that acts with malice to deny the other parent their lawful visitation or custody, that would be the trigger, right? Well, now law enforcement looks at that and goes, is this parent acting with malice, right? Intent to commit harm to the other parent. It's because law enforcement doesn't understand that the legislature intended anytime somebody knowingly, willfully, with wanton disregard for a court order denies that or defies that court order, that is in and of itself malice. So right there, I'm using that as an example of if the legislature thinks that they know what they're talking about, but they're not speaking the same language as law enforcement really can't enforce it. Now, can it? Now, I'm going to skip down to subsection 6. There are 3 situations and then 2 conditions to where it says these situations, in these cases, the law shall not apply. Custodial interference shall not be enforced. One is if the person who's taking the child was a victim of domestic violence, right? Right away, you can say, were they a victim today, last week, last year? Was it the other parent that was even the perpetrator of the domestic violence? This is sloppily written, right? Second situation, if they believe or have reasonable cause, that's what I should have said. If they have reasonable cause to believe, right? There's a legal distinction there, that they will become a victim of domestic violence. Really hard, right? That now we're talking precog, minority report stuff. The third situation is if they believe and simply believe that their actions are necessary to preserve the child's well-being, which is code for do they believe their actions are necessary to protect the child from child abuse or domestic violence. Then there are 2, now that's crazy on its own, right? Now it's just belief. Now there's not even a reasonable cause or any standard. It's just a belief. There are 2 conditions in order to satisfy this. It does not apply, right? The law shall not be enforced. One is within 10 days, the abductor would report the location of the child to the sheriff's office or the state attorney's office. This language is so archaic that the state attorney's office won't even take the call these days, right? So this is going back to perhaps 1975 when the law was first enacted. The second condition is within a reasonable amount of time, the abductor will essentially file with the court a request for a change of custody, right? Within a reasonable amount of time, on its face, it's understood by the legislature what they mean. Law enforcement doesn't know what to do with that. Law enforcement cannot enforce a reasonable amount of time. So the entire statute gets thrown out. This is why law enforcement never once in the state of Florida has actually charged somebody with custodial interference under 787.03. Doesn't mean that a state attorney hasn't. The reason why we know what state attorneys have done is because we have the appellate, or we have the appeals to reference. So we know that somebody has been charged with the crime in court. It just somebody hasn't been arrested for these matters. Now going back to what it says in that condition, within a reasonable amount of time, the statute on its face is constitutional, but it has the effect of being unconstitutional if law enforcement can't enforce or doesn't understand how to enforce it. What it allows the abducting parent to do is to temporarily or perhaps permanently suspend the other person, the other parent, their 14th Amendment rights to parenthood, right? The right to parenthood that's protected under the 14th Amendment. And under the Constitution, Article 1, Section 10, no state shall create a bill of attainder. So essentially what they're saying is you can't create a law that on its face does or would have the effect of allowing the government or another person, a citizen, to deny somebody of their constitutional rights without due process, right? Without the court being involved. And that is essentially what's happening in this, right? Quick overview of what's going wrong with 787.03. Thanks.